I've already talked to
If we could have the roll call, please.
Tyler Markham.
Here.
Mark Ferry.
Here.
Steve Ballett.
Here.
Amanda Cook.
Here.
Jacqueline Trainier. Rachel Ventura.
Present.
And Tom Weigel.
Here. Rachel, since you're standing, come on, lead us in the pledge.
I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Alrighty, so first up we have approval of the minutes from June 11th.
Second.
It's been moved and seconded. All in favor signify by aye. Aye. Opposed? Motion carries. First up under new business, we have zoning case ZC-19-017, which is a map amendment from A1 to R3 at 34256 South West River Road in Wilmington, Illinois, County Board District Number 6. So Jessica, you are up.
Thank you, Mr. Chairman. And I will have just a couple of images on the screen here for you, which might be helpful. They're also included in your staff report, but just to reference as well. So as you have stated, ZC 19017 is a request for a map amendment from A1 agricultural to R3 single family residential. The purpose is to bring an existing parcel into compliance, as well as allow the current property owner to make improvements to the property. He is building an addition to the home as well as remodeling the existing home. So building permits with that remodel and addition are in our office. The owner and applicant is Richard Lean. The subject property is located at 34256 South West River Road in Custer Township. So I have just two images here. The first one is the zoning map. So as I mentioned, it is A1 agricultural. It's 1.24 acres. The parcel was created in 2001. And so it does not meet the minimum standards for an A1 zone parcels, which is 10 acres. It does have plenty of frontage along two roads because it is at the intersection of Southwest River Road as well as Illinois Route 113. So the parcel meets the minimum lot standards for the R3 zoning district. There is an existing residence. There are some existing sheds as well. Those structures meet the minimum setbacks for that zoning district as well. So there aren't any variances being requested in addition to the rezoning. And as you can see on that zoning map, within the general area, there is A1 zoning, so you can see it to the south and to the west. And then to the east is where you're going to see some of that residential zoning. So we have R3, R2, R1, A2, which is that agricultural residential, and some E1 right there to the north. The subject parcel isn't used for agricultural purposes, it is used for residential purposes, so the rezoning is appropriate for what it's being used for. It is located within the rural form under the Land Resource Management Plan for Will County. However, its development has been influenced from that nearby residential along the Kankakee River. So for those of you who aren't familiar with this area, there is residential development along the Kankakee River. Those residences initially were just these small neighborhoods and subdivisions that were intended to be summer homes or summer retreats, and then over time became permanent residences. So that's why you have, although they're within this rural form, pull up here. Here is our LRMP map. So it's kind of hard to see there, but all of that green indicates that this is within a rural form. You can see right here, those dots indicate the Kankakee River corridor. So that's where you're going to see within this form those small residential lots, which are otherwise inappropriate in the rural form. So this parcel is kind of on the cusp of that, so it matches that development. So staff does feel that it's an appropriate rezoning. And from our research, the property has been deficient for many years. And over time, as they acquired more property and became larger, still didn't meet those A1 standards. The Will County Planning and Zoning Commission held a public hearing for this case on July 2nd. They voted unanimously for approval of the 4 commissioners that were present. And staff is also recommending approval of the rezoning based on the map amendment criteria.
Does the committee have any questions? Mr. Lean did sign up to speak if you would like to.
I'm here to answer questions if you have any.
Motions.
All right, it's been moved to approve in a second. All in favor signify by aye. Aye. Opposed? Motion has carried. So next up we have other business. Number 1, Bulletin 70, amending Chapter 15, Section 55.005, definitions in Chapter 164, Section 164.004, definitions and technical guidance manual references. Who wants to?
I got that.
All righty.
So the state, Illinois State Water Survey has changed the data that the engineers use to determine things like detention ponds. And basically, I guess Janine, if you want to really quick, if you don't mind, put the first PDF up there. Sorry, I should have caught you first.
Can you have your name
My name's Scott Killinger.
with an engineer?
Yes, I'm the county chief subdivision engineer. Yes, I know all of you and a lot of you know me, but I realize some of you don't, so sorry.
This one, Scott?
Yes, please, I should have caught it earlier. So basically, there's this new book, and it says updated Bulletin 70. The current book in the ordinance is Bulletin 70, so now we need to go to updated Bulletin 70. Basically, the Stormwater Committee's talked about this for their last 3 meetings in May, June, and July. Now I'm here because the ordinance requires to change it. I'm going to show it to you today, answer your questions, and then I'm going to ask you to bring it back in August for a public hearing, and then we'll take it to the county board to be codified there. So there's basically now, if you go down to the first one, Janine, thank you. There's basically 3 places where we need to change. Chapter 55, and some of you are going to recall, we did this when we adopted the digital floodplain maps about 6 months ago. Chapter 55 is actually the county-wide ordinance that all the communities that are certified stormwater communities in the county adopt. So we need to change basically in the definitions, instead of saying Bulletin 70, we're going to say updated Bulletin 70. It's pretty simple. Another related item that we're going to change in Chapter 55 is there's a substantial damage definition, and this chapter actually is not, the state wants us to say that the repetitive loss should be 10 years rather than the life of the structure, because 10 years is easier for the residents to deal with. I can explain more of that if you've got questions, but so we're going to change those in Chapter 55. If you go to the next one, Janine, go to 164. Sorry, yeah, back. Okay, so again, in Chapter 164, we're going to change where they reference Bulletin 70 to updated Bulletin 70. It's pretty straightforward. And then in the last one, it's a little more complicated. So go to the third, I think it's the bottom one. And this is the technical guidance manual. And in the technical guidance manual, we actually get into things like the actual data that we require them to use. So in this one, there's more extensive changes. And again, I can answer a lot of questions about this or not, depending on how much detail you're interested in. Basically, what we're doing in here is, if you just go ahead and scroll down, we're going to change the tables so that, let me keep going. We're going to change the tables so that all these numbers that were that's the old rainfall data, and we're going to put the next, go on down the next page, we're going to put in the new rainfall data. Now, some background on this, the old data is from a publication in 1989, and the data were collected from 1948 to about 1985, okay? The new one is based on data that they've collected from 1948 to the present time. So if you think about statistics, there's a lot more data, so it's a lot more better predictor of what's really going to happen. In general, what they've found is, you know, we talk about it's the 1% storm, but everybody knows it is the 100-year storm. It's all famous. what we found is that that one really didn't change very much. On an 8-inch rainfall, it's about 1/4 of an inch more. So in other words, there's really not that much impact. What they did find in the new data is that the shorter storms, like the 2-year recurrent storm, the storms we get a lot more often, like, you know, in May, those are more robust, more intense. So you're getting a little more at the lower end, which means you're getting more smaller events more frequently. And so that's probably the best way for me to just generally tell you what this does. So I think that's pretty much everything I'm going to say, and let you ask what else you want to know about it. Like I said, the Stormwater Committee talked about this. The Stormwater Committee spent quite a bit of time because there were actually some data up in the smaller ones there, like the 10-minute and 15-minute that the state didn't give us. And to design storm sewers in a subdivision, you need those. So the Stormwater Committee, we decided to just take the old data and just use the same old numbers because we don't have anything better. So that way engineers working in the county will have something to go by. So.
Committee members, do you have any questions?
Motion, can we scroll back 2 pages? Or somewhere in there. Okay, so under section T202-2, under 1, return period, why doesn't it say it requires updated Bulletin 70 there where it says updated Bulletin everywhere else?
That's probably something we should do, so thank you. I'll do that. The big thing here was the Northeast Sectional Code. That's actually the rainfall data that Will County's in. There's a map of the state, and obviously we're in the Northeast section, and there's, you know, whatever there is, 6 or 8 sections. It's in the original code. But anyway, I think that's a good point, and I'll change that to say updated.
Anybody, any other questions?
With these charts in there, does that give us assistance if we're dealing with other counties in working with them that they have to fix things that's their problem? Where I live, Wilcook Road floods like it does in Orland Park with Southwest Highway, and it's all due to Cook County putting all their water to us. So now does that, this is a tool that we'll be able to use to say to them,
so
you must fix it?
all of the counties in the state will adopt this, and I didn't say it'll be, the state has said it should be effective January 1st, 2020, the new data. So then everybody doing work in the state will all be designing to the same standard, which is really what they do now. Specifically, your question, Cook County, for example, will be using the same data, but this, in other words, it's not like this is going to give us any different way to dispute something if we're getting runoff from them. It wouldn't be any different than it would be now.
I was just thinking because of the increased volume that we could show them that, you know, their design is for 20 years ago and now it's different.
Well, yeah, of course, anything that's already designed is going to remain the way it is. I mean, nobody's probably going to go back and retrofit things. I mean, I understand, I think, your question. It's just, I don't know that this is going to change anything from a legal standpoint. It's just that now it'll be designed with a slightly more robust rainfall data. New things going forward.
This problem's been the last probably 10 years. But what you're saying is they won't go back and fix the stuff.
They won't go back and, I can't really say what any county will do, but I wouldn't expect that anyone is going to go back and retrofit things.
I brought it, 5 years ago, I brought it up and nothing could be done. They didn't want to cooperate.
Yeah. And so this wouldn't have any effect on previous things.
All right, so it's been moved. Is there a second?
Second.
It's been moved and properly seconded. All in favor signify by aye. Aye. Opposed? Motion has carried. Next up, we have number 2 under other business, amending section 155-9.130, cargo container regulations, and 155-10.10, accessory uses for cargo containers.
I want to motion to move this forward with the amended for section D, where it says the cargo container shall not be installed or constructed vertically. We spoke last time that should say to be placed on the vertical end. So I'd like to motion to move forward with that amendment.
Okay, all right, we're gonna get a presentation. Yep. All right, we'll deal with that after the presentation real quick.
Could you repeat that? I couldn't hear you.
Last month, we talked about clarifying what vertically means and to change it to they can't put the cargo container on its vertical ends. As opposed to just saying vertically, one could interpret that as this is vertically. So just to clarify that was all.
So we'll come back to that after we get this, so make sure it's all kosher.
Thank you, Mr. Chairman. So today is basically just a status update on where we stand. Colin is not here, so he will be presenting this to you next month, a formalized, finalized draft for your review and comment. So I wanted to just provide where we are right now with this. He's made some changes, and I appreciate that comment. I wrote it down to pass along to him. Some changes made regarding the roof, because we had talked about the pitch versus peaked versus flat. So he's incorporated those changes. He's also incorporated the changes regarding the vinyl siding. If you remember, it was prohibited, so now that's been removed. The one question that we do have for you is, should this be a special use permit or not? That was something that was discussed. There was really no consensus at the last time that this was discussed. So again, a special use permit would allow us would allow the county board some greater control over the design or placement of the cargo container house, or it could just be permitted as of right, and land use staff would review the guidelines that are currently in place and then would approve the permits accordingly. So we're looking for some guidance on that.
Well, from my personal point of view, I would prefer it to be a special use permit, but Amanda?
My question is, how much does the special use permit cost a homeowner?
It will depend on the acreage, but typically the house is not going to take up more than an acre. I mean, that would be a really large house. So it would be $675.
Okay.
I'm in favor of the special use.
Steve?
Special use.
Mark? I think we agree that special use, and if we run into issues, we can always come back and revisit it, so.
Sure, and like I said, this will be back over in Cowan next month.
All right, so then we got what we talked about a couple months ago with the vertical.
Yes.
Can I just ask a question on this? So I was trying to read back, are you allowing them to stack? Yeah. So more than one on top of one another? How far are you going up?
Well, it would depend, the height would depend on building code.
I think it maxed it at 2. That was in the.
Yeah, I believe building code wise, they would not even be able to do more than
Okay,
two.
that's what I was asking.
No, it's 5-D, no more than 2 cargo containers are permitted on a single lot. So,
Okay.
I mean, whether they put them here or here, they're going to be stuck with the 2. Well, that doesn't, that's the.
For the other uses though.
It is in here though.
Well, and that's kind of dictated by building code. It has to fall under everything with building code. So since we have a height requirement and limit for the building code, they can't exceed that. Otherwise, they would not be in conformity. So does anybody else have anything else they'd like to visit with this for Colin for next month? Julie?
Tyler, there was some discussion on this previously about making these a little greener. I know if you did allow a flat roof, that would allow a living garden or a living roof. Also, it specifies architectural grade asphalt and fiberglass shingles for roofs. If we want to make this a little bit greener, then I think it would be good to think about making a couple changes to allow the homeowner to maybe have solar or a living roof.
I think that the silicone is made with fiberglass and glass. It seems like wouldn't that encompass that? Does it need to be spelled out specifically?
I think, and I'd have to look at the language right here, but I think if they are saying that you have to have an asphalt shingle roof, then there would be no variation from that. So taking that comment, I'll bring that back to Colin, that we should allow for a green roof or a living roof.
And they also have these solar shingles now that are becoming very popular, and it gives the homeowner the ability to have an energy producing roof rather than just asphalt shingles. Thank you.
Thanks, Julie. Anybody else? So, okay.
Yeah, wait, let's clarify
Rachel?
that. You want me to ask you?
I see that, I see that vinyl or aluminum horizontal siding isn't prohibited. We already talked about this, we're going to move it to accepted, okay.
Yeah, that they will allow you to do that now.
Okay.
Anybody else? All right, so we'll see Colin next month. So moving on to number 3, which is amending sections 155-7.30, use table, and 155-9.170, which is A1 mobile homes of the Will County zoning ordinance.
That's me as well, yes. So again, this is just basically for discussion right now, and depending on the outcome of today's meeting, we'll have the language for you for review next month. This is something that was brought up before you last month about allowing a mobile home in the C6 zoning district, which the C6 is like an entertainment district. A lot of our recreational clubs are located in C6. So allowing a mobile home for like a caretaker or security personnel on the property. This is a provision that under previous zoning ordinances prior to 2012, that it was allowed and then it was removed in 2012, but we've had some traction lately about reintroducing this concept. So staff under the committee's direction has provided 2 changes that we could potentially adopt here, and the one is in the use table where you see mobile home, and we're just basically adding it as an S, as a special use permit in the C6 zoning district. And then we have here where we actually have the general guidelines about mobile homes and mobile home parks, adding in a simple sentence there about it's allowed in the C6 district for caretaker or security purposes with an approved special use permit. So that's where we stand right now, and just looking for guidance to then bring back the language for a public hearing.
I have a question. Why would you need a special use permit to allow it? Is that how it was in the past? Because it seems like it's just an added cost for something that should be allowed.
Well, and that's what it was in the past. It actually was a special use permit.
So why do we have, we're amending it, why would we have a special use permit for something that, if I own an industrial property or any kind of property and I want to put a security trailer on it, and have to, because it's 24 hours a day, why would I need to get a special, I don't see a reason, because obviously it's not going to be in a residential neighborhood.
Sure, so we do actually have the provisions of allowing for like a security personnel in the industrial districts, and that is a special use permit currently. But if the committee feels that this could be permitted as of right, that's fine. We can make these changes and bring it back next month.
I have a question on it. If that was if it was right, then I guess my concern is, how do you make sure that only one is there? You don't want a whole mobile home popping up at an industrial park, right? So is that the special use helps limit that?
Well, the special use would allow a little bit of greater control over the mobile home itself and where is it being placed, and making sure that there is only one, for example. With these mobile homes, sometimes people just bring it onto the property and they don't get a building permit, so there can be issues with that. Again, it's just sort of up to the committee if they would like it to be a special use, which it was previously to 2012, or if it is permitted in the C6 district.
Your language just says for caretaker, that's one, that's not multiple, it's one. And then if someone put 2 up there, that would be in violation.
Correct.
So they're only going to have 1. And if they put it in a you're talking about putting it in a bad location, so everything's got to be code. So, again, if it has to meet code and they can only have one, why do you need a special use permit? Because I don't know what the rest of the people think, but I don't think that we should say no to one.
I think if it was special use before, there were probably clear reasons as to why. And my concern is that when you just willy-nilly allow it, they don't have to come in and apply for something, you run the gamut of them not doing it correctly and not only having one, not placing the correct locations. So this is for guidance of what would be within our building codes and stuff. So I think it should be special use.
But you guys do inspect, don't you, when they,
Through the building permit itself, yes.
so they would know if they did something.
So my question is, how often does this come up, do you know, in the past?
So previously, again, the ordinance changes in 2012, so it hasn't been that long ago. So we do have situations where this is existing, this is legal, non-conforming as we call it. It's fine, it's okay. But recently we did have one property, the Palis Sportsman's Club, I believe it was called, her name escapes me, where they had this existing, they had the mobile home on the property, and then they took it out to bring in a brand new one, and the violation ensued because of that. So they're not allowed to do it anymore, even though it was something that they may have had for years, and our aerial photographs show that it was like since the 1970s that they've had this. So it's something that I think right now we have one situation, but is broadly applicable because we have current properties that are doing this because they are grandfathered in, and the potential to have existing ones that may not have this, give them that opportunity.
Does anybody else on the committee have anything before I
Can I
go?
just ask a
Yeah,
question?
just,
Hold on, anybody else on the committee? All right, we're gonna go Julie and then Jim.
Okay, so there's a difference between a house and a mobile home in the fact that for the structure to be secure and the foundation for a mobile home is much different than a house. So I'd like to ask the staff, for that reason, do you feel that a special use permit should be required? I would be interested in your expert opinion. And then also, when you go down to item number 8, it also indicates that you need to provide a storage space for the mobile home. And if they haven't, if they add a storage shed, there will also need to be a special use permit on that storage shed as well, correct?
We would allow them to construct, like, if we have a C6 property, I'll use as an example, some of our recreational clubs. So they're allowed to build a little clubhouse, they're allowed to build storage buildings where they can have the equipment to maintain the property. So we would look at it in that way where it wouldn't be a special use permit because it's for the maintenance of the property as a whole. Maybe it stores the lawnmower that's being used to cut around the mobile home, but it's for the property as a whole. And then as in regards to the special use permit, it predates my time here when they made that change in the zoning ordinance. So I feel that it became a special use because there probably were situations that had come about where the board felt they wanted a little bit more control over this, perhaps in relation to screening or the location of the mobile home on the property. So it just, again, it would be, a fee for that special use permit, but it would allow the board some more control over the mobile home itself.
Jim?
Yeah, I'd like to point out a couple of things. A special use serves a couple functions. And one of the primary functions is it goes into a public process. So there is input by the community, there's notification of the surrounding property owners, so they know that something is a change that may or may not be in character with the area. And it also gives the county board the ability to place some conditions on special use permits. And both of those functions, I think, are very important. And I do think when something is maybe out of character for the general area, that there should be a public process, so there's, so there's public input. So that's the other function of a special use, which I think is extremely important, and it gives us, I think, pretty, it gives us transparency to the public that I think is appropriate. Thank you.
Gloria, did you have a question?
No, never. Thanks.
And I tend to agree with Jim that I'm comfortable with it being a special use permit because it's not really a common occurrence for that district, so I tend to agree that it should be a special use permit. So, does anybody else up here want to, one last word?
I would agree with that.
All right, so you have all that for the next one. So moving on to reports, communications, and correspondence.
I wanted to bring up one thing while Scott was still here for, this would be for the next, is this the right place?
Yeah, go ahead.
Okay. So I don't want to get too much into details of it, but there was a case in Mokina that talked about some flood water. And while I understand you may not be able to help that individual, it brought up a bigger issue of, as we have rogue rivers and rogue stormwater overflowing ditches and bigger rains, like we just saw the rainfall numbers changing, how is the county prepared to deal with some of these things when the stormwater committee and the township committee don't have funds to maybe take on some of these bigger projects? And I know in the past, even in the county, we've used CBDG money to help with retention ponds or drain tiles or drainage. And so I think moving forward and having the forethought that things may be changing in the next few years, that we have a good policy of how we should deal with this, so that when people come to us and say, well, this is happening to me, what do I do? And we have some type of idea. So I don't know if anyone here has any ideas or if the staff has ideas, but I would entertain future meetings, having some type of presentation, maybe what other counties are doing or what options might exist for if we get massive flooding. What are we going to do for our residents of Will County? So I'd like to see that in the future. Thank you.
Kim?
Yeah, thank you. Rachel, I'm glad you brought this up. My first initiative when I got onto the county board was to try to get a countywide stormwater management plan in place. And it took me, I think, 3 years before I could actually get the board to want to take it on, and the executive's office at the time. So it was quite a struggle. But we did pass one, and stormwater management committee was formed. It has equal membership from municipalities and the county, and they developed a plan. Even though it was a very base plan, I'm just going to give you a little background. It was a very base plan. We felt that it would improve over time. That we would amend it over time and get to a better place. But the one thing that never happened until maybe, I don't know, Scott, maybe a couple of years ago, we never funded any money for remediation, even though there could be an occasional grant that came through. So I do support in the upcoming budget that, we continue to fund it, and maybe even fund it at a little higher level, and of course put a little pressure on the stormwater management committee, staff, and surrounding areas, specifically townships and so forth, to get their acts together so they can get these projects to the county for approval. And I do know, I think Scott talked to, in this particular case you talked about, I think Scott did talk to the Highway Commissioner in Frankfort Township. But you also have to understand that many of these areas, the one you mentioned being one of them, this has been going on for 50 years. These are homes that probably should have never, and by today's standards, would never be allowed to be built.
Right.
Now that doesn't say we shouldn't try to remediate areas where there's this many existing homes. But on the other hand, should we be remediating areas that are meant to flood? I mean, so the reason I'm mentioning this is is that certain areas are met, that's where the water goes. Even if they do have a house there, sorry to tell them that's where the house goes. Maybe Scott can make some comment also. But we do have something in place, and hopefully we'll continue to fund it, and hopefully we get some projects completed. But I do think we have started on the right direction, and we need to continue to push. And of course, we need to educate ourselves. There's some areas that probably can't be helped without affecting the whole way water flows. But
I think that was more of my point. I mean, I'm glad that the Stormwater Committee came into existence, and I'm sorry it took so long, and I do think we should fund that and be, like I said, have the forethought of what might be coming in the future, be prepared for that. But I think to your bigger point is, like this particular case, that should probably be a retention pond. I mean, I don't want that person to sell the house to the next person, because that creates a problem, but then how does that person move out without selling the home? You know, is there a buyout program? There's no money for a buyout program right now. You know, is there another option? You know, annexing. Well, now that becomes the city's problem. So I'd like to see some, you know, maybe some ideas about policy that would help dictate some of this, or what other cities have done in this case, because this might be a one-time incident here, but you know it's somewhere else in the county. It has the same problem, and it's going to continue as rivers take over ditches. And now you've got, like you said, where the water pool's at. And you had a community built there 50, 60 years ago. Well, we don't have a bunch of money then to buy out a bunch of homes. So how do we have forethought to this? How do we save money? How do we get grant dollars? These are all things I think that we need to start looking at now before we have those problems and we're chasing our tail.
the only other thing I would say though, is should public money go into, should taxpayers' money, public money go into on private property? Because keep in mind, this is private property.
Well, if the river changed course, it's no one's fault.
Well, the river didn't change course, I don't think. I mean, water flows where it flows, and it has flowed that way for thousands of years. But my point is you should also keep in mind that, you know, you're making improvements to private property. You have to, it's a fine line between the public use and a private use of taxpayers' dollars. And I might also point out now, one of these people have bought these properties without knowing it's in a floodplain. Now they may come out in the middle of August when it's dry, because it's beautiful when it's dry. You know, but they know it. They're buying floodplain.
Well, this particular case actually is not in a floodplain, though. I mean, so that's what I'm saying. As flooding is occurring in the state of Illinois, we look at these farmers who can't plant their crops. It's happening. So to your point, you know, if we have right-of-way to take for highways, why would we have right-of-way to take for retention ponds? It helps flooding to prevent flooding for everybody. I mean, there's an argument to make here, but my point is I'd like to see some things brought forward so we can have these discussions in a more knowledgeable platform. You know what I mean?
So it sounds like we can get that information to everybody so we can all take a look at it. I mean, we don't want to do something based on one incident,
Right.
just the one thing alone. So we'll get the information, take a look at it. I'll make sure that the whole board gets it, just so everybody kind of knows. And if there's something that we want to talk about, we can bring it back in the future when we actually have all the information in front of everybody. Sound good? All right, so on to reports, communications, and correspondence. I have nothing. I'd just like to thank land use staff. I've been getting a lot of calls and stuff, and I've been bothering them a lot, and they've been very helpful to me, so kudos to you guys. So does the committee members have anything? Nothing? Janine, you're only one left, I think, so nothing. Public comment. Going once. That's a real big public out there. Going twice. We don't need executive session. That's why Mr. Guzman gets big bucks, because he never makes us do that. So I'll entertain a motion for adjournment.
Motion. Second.
Then moved and seconded. All in favor? Aye. Opposed? Our next meeting is August 13th, and it's in this room. So everybody have a good one.